Bussert, I'm going to start with you to let me know if you think, nope, we're actually here to talk about child support modification.
Your Honor's summation is correct. We're here on the show cause order regarding Ms. Pinckney's use of AI and the hallucinated citations and misrepresentations of statutes.
Okay, got it. Ms. Chauvet-Maldonado, anything you want to add to just sort of procedurally why we're here, what's going on?
Excuse me, Your Honor, I neglected to unmute myself. Your summation is generally correct, but we would like to clarify a few points related to the citation error with hopes that the court will be understanding of how this all came about. Thank you.
Okay. Great. Well, why don't you do that? I'd like to hear from you, and then I will hear from Mr. Bussert. And then we also need to make a plan for going forward. Let me pull this up, the docket, because I want to make sure before we sign off, we're also all aligned as to what's next. Because I think this all flowed out of a motion to reconsider something that had been done, and it was in that motion for reconsideration maybe that some of these hallucinations crept in. So, Ms. Chauvet-Maldonado, why don't you share with me what you wanted to?
Your Honor, Chauvet is fine in the interest of being brief. So, good afternoon, Your Honor. My name is Chanel Chauvet-Maldonado. I'm appearing on behalf of Respondent Adrienne Rochelle Pinckney. We appreciate this opportunity to clarify in this court's hearing to show cause. Now, before I get started on how this all came about, and I understand that I have just 30 minutes to clarify, I do want to note that Respondent acknowledges the citation issue. She accepts responsibility for the filing, and she respectfully submits that the court record reflects that there was an inadvertent mistake, not necessarily a bad faith filing, nor any attempt to mislead the court. I hear a bit of an echo, so I would kindly ask that my opposing counsel mute himself.
I'll take care of it. All right.
A routine child support discussion quickly shifted into something far more unusual. The courtroom instead focused on allegations that artificial intelligence had introduced false legal citations into an important family court filing.
Okay, thank you. So with respect to acknowledging the citation error, now there was just one citation in the motion for reconsideration that could not later be verified. This error was inadvertent and not an attempt to mislead the court. And actually, as soon as respondent learned about the issue or realized the issue, she promptly corrected the record by filing an amended motion in which she withdrew reliance on the citation.
Ms. Chauvet, did Ms. Pinckney figure out that it was a bad citation because she went behind the work she did and double checked it? Or did it come to her attention because Mr. Bussert had to file a motion saying, I don't even know what I'm dealing with here. There's this case, I can't find it anywhere. I think we've got an AI issue, Judge.
No, Your Honor, and I'll actually explain how this all came about. She filed it within, I think it was within 1 or 2 days, and this was before Sean Bussert ever filed a response. So again, it was not in response to any filing from opposing counsel.
Okay.
And again, I'll get to how this all came about. Now, I noted that she acknowledges the error. I think it's important to note for the purposes of this hearing that respondent has authored her own pleadings. In fact, she has an extensive educational background, including a PhD from Emory University, which demonstrates the experience she has in writing generally. Also, this isolated error is inconsistent with any sort of inference that opposing counsel listed in his brief of any intentional deception, as the isolated citation error was simply an oversight and is not evidence of respondent's lack of authorship of her filings or that she intended to deceive the court. Now, regarding how this all came about, Your Honor, while researching on Google, respondent encountered the citation in her Google search. There's a new feature called Google Overview. And after searching for case law on the platform related to the issue that she was attempting to bring to the court in her motion for reconsideration, she mistakenly believed that it was valid. Admittedly, she did fail to independently verify it before filing it, but when she later attempted to verify it and realized that she could not verify it, and also realized that the overview provided to her in the Google search was actually a new AI feature that the platform has added to its Google searches. So once she realized all of this, she immediately withdrew reliance on it, again, within 1 to 2 days, and she filed that amended motion. With that being said, she does still accept full responsibility for this mistake, but I wanted to share the overview about how this all came about and how she immediately corrected it upon learning about this new feature. Now, regarding good faith for the basis of her motion, she filed this motion for reconsideration to present additional sworn evidence relevant to jurisdiction. Now, the motion was based upon a genuine dispute regarding the proper forum under the UCC JEA. Importantly, the parties' mediated settlement agreement.
The respondent's attorney acknowledged the citation error immediately, insisting it resulted from an honest mistake rather than deliberate deception. According to the explanation, the disputed authority originated from Google's AI-generated search overview.
That as of August 2025, both parties contemplated that the children would reside in Raleigh, North Carolina, and that the father, petitioner, intended to relocate there so that the parties could exercise equal parenting time. Now, respondent relocated in reliance upon those representations and believed that North Carolina had become the children's home state. Now, although that particular agreement was never incorporated into a final order because the underlying action was dismissed without prejudice, respondent relied upon those representations when relocating their children. So this provides important context for why respondent later believed, in good faith, that North Carolina had become the appropriate forum under the UCC JEA. Now, the evidence addressed regarding the children's residence includes records related to school enrollment, medical care, and the parties' mediated agreement concerning relocation to North Carolina. The motion itself reflected a genuine legal disagreement regarding jurisdiction, not any sort of delay, harassment, nor abusive process. Further, when North Carolina became the children's home state, she actually filed an action in North Carolina prior to ever being served regarding the Georgia action, because she genuinely believed, in good faith, that it was the proper forum. Respondent filed her North Carolina custody action on February 11th, 2026, earlier this year. This is after North Carolina became the children's home state, and respondent was not served with the Georgia action until late March, earlier this year. So probably about 2 weeks to a month after she had filed the North Carolina action. I do want to note for the court's attention that the North Carolina custody action is pending before Judge Crystal Grimes, with a hearing scheduled for September 9th, in just about a month. And petitioner has appeared through counsel in that action. So communication between those courts will actually help avoid future conflicting issues, including potential custody orders. We respectfully request that if the court reaches jurisdictional issues, that it confer with the North Carolina court.
After realizing the cited case could not be verified, the respondent promptly filed an amended motion withdrawing reliance on it. Counsel emphasized that responsibility was accepted while maintaining the filing reflected genuine legal arguments. Pursuant
to OCGA 19-9-66. I have just a few more points, if you'll bear with me. The next point relates to the good faith argument under OCGA 19-9-67. Now, Georgia law expressly permits a court to decline jurisdiction if Georgia is an inconvenient forum. Now, respondent's motion addressed factors.
I'm going to object at this point. We've gone beyond the show cause hearing. We're trying to get into jurisdictional issues that have now been ruled on twice.
Your Honor, I'm explaining how this all came about and why.
Okay, stop. Okay, got it. I don't need additional context. I am looking at Judge Ellerby's order dated May 5, 2026, and the law of this case that binds me, a co-equal, co-peer of mine, indicated that this is the appropriate forum for this litigation. We're going to have a conversation this afternoon about what are we going to do about the fact that there is a North Carolina case about custody going on as well? But I'm aware, Ms. Chauvet, that Ms. Pinckney very vigorously, in a perfectly appropriate way, challenged jurisdiction and pointed to all the reasons why North Carolina was the appropriate forum for any custody dispute between Mr. Negron and Ms. Pinckney. That's not what Judge Ellerby decided. And so here we are, and here we stay. But I feel like you've provided sufficient context as to why Ms. Pinckney was seeking to have Judge Ellerby reconsider the order denying the motion to dismiss and the motion to stay. That's not what Judge Ellerby did. And that ship has sailed. And what we're working through today narrowly is what are the consequences, if any, of the, I'm going to call it over-reliance or mis-reliance on AI. You've shared with me that you believe, or Ms. Pinckney tells you, that she didn't know it was AI. It was computer-aided research either way. And we need to sort out what all that means. We'll also, on a broader topic, figure out what are we doing next in light of what you shared with me, which is a September hearing date on the custody case, for the custody case in North Carolina. So if there's anything more you want to add about the misrepresentations that were in
the judge redirected the hearing toward its central purpose, explaining that jurisdictional disputes had already been decided previously. The remaining question was whether misuse of AI and inaccurate legal citations justified sanctions against the respondent.
The motion for reconsideration, I'm happy to hear about that.
Yes, Your Honor. Perhaps I can proceed with why sanctions are not appropriate here.
Great.
Okay. First and foremost, there is no evidence of bad faith, nor that this was a frivolous filing. In fact, the mediated agreement is useful insofar as it explains in good faith why respondent believed that North Carolina was the proper forum and why her motion was filed in good faith, not necessarily because it independently created enforceable custody rights.
Well,
October.
I don't believe Ms. Pinckney engaged in a debate about jurisdiction in bad faith. I think she was perfectly justified in doing so. It's just not the argument that carried the day with my predecessor. So yes. You don't need to convince me that there was vexatious litigation or harassing litigation. That's not what I see here. And Mr. Bussert will respond in a minute, but if he's going to take the tack that, gosh, Ms. Pinckney is one of these, because we have AI litigators who just go on and say, give me 5 motions that will make the other side's life more difficult. And AI spits out 5 motions that'll make, and that's not this at all. I understand why Ms. Pinckney was pressing for the outcome she was pressing for. It was well placed and it was well reasoned. Whether it's because she's a PhD from Emory or because she got assistance, that doesn't matter. It was very well reasoned. It just happened to not comply with some pretty clear directives from Judge Ellerby about the use of AI or Google Assist or whatever. And so it's really that narrow. Ms. Pinckney is not appearing in front of me behind some 8 ball of, why were you saying it shouldn't be in Georgia? I'm not possessive about cases, and I understand entirely. She's in North Carolina. The kids are in North Carolina. If you just put them in the scales of justice, look where the weight is. It's all in North Carolina. But again, that's not the ruling that was made. So let's stick to the, what do we do about the fact that that brief, that motion to reconsider didn't comply with Judge Ellerby's instructions?
Yes, Your Honor. Thank you. In fact, the reason I mentioned it is because if you view opposing counsel's brief, it does seem to indicate that there has been a series of frivolous filing, this being the case here, and that also he's permitted sanctions for...
Although the court rejected claims of bad faith litigation, concern remained over failing to verify legal authorities before filing. The judge distinguished legitimate advocacy from relying upon research that had never been independently confirmed.
attorney's fees, I should say, because of that issue. So I did want to address it as it relates to sanctions and why they're not appropriate. I do also want to note for the court's attention that my client has already incurred significant litigation costs in this dispute, well over $60,000, and has received no child support to date. In fact, since August of 2025, respondent has been the sole court caregiver and financial provider.
Stop. Both of you stop. When you hear an objection, you got to stop talking. And I'm a little confused. You piqued my curiosity, not about the child support, because that's not what we're here to talk about. But the sense I got from looking in the docket, but I did not look in the older docket to which this case relates. Ms. Pinkney's been representing herself, and it is a cardinal rule that you don't get to collect your attorney's fees if you're self-represented. In what context did Ms. Pinkney incur 60? I mean, you may have a real high retainer, and that could be the 60,000. But if that's not it, where are legal bills coming from in this case?
So, Your Honor, I am actually appearing on a pro bono basis, given my client's financial situation. She has incurred attorney's fees through the guardian ad litem case, and then also through previous filings. She had another attorney that she engaged prior to this that helped to support her in a series of meetings, including the mediated settlement agreement.
Got it. Okay. Well, I appreciate your appearance on her behalf in the manner that you're doing it. And so those are legal fees from the case that preceded this action.
Yes, Your Honor.
Okay. Got it.
Okay.
All right. How about we do this? I'm going to pause you. I want to hear from Mr. Bussert a bit. I'm going to give you a chance, Ms. Chauvet, to respond. If you feel like Mr. Bussert has taken us out of focus from whether there should be sanctions, and if so, what they should look like for the miscitation of one case. And I know from reading his brief, he believes that there was some elasticity given to a couple statutes. And so I'll hear him on that. But I think some of what you were starting to share with me was more predicting what it was that Mr. Bussert was going to hear about, but I'm going to give you the last word.
Attention then shifted to litigation expenses and prior representation. Questions arose regarding substantial legal fees despite self-representation, leading counsel to explain previous attorneys and pro bono assistance throughout the lengthy custody dispute.
And that way you'll be able to clear up anything that you think Mr. Bussert might have made cloudy through his presentation.
Thank you, Your Honor. And if I could simply note, I was actually getting ready to close with 4 last points. Not sure if you still want to proceed in the same way.
Why don't you save the 4 last points? I will hear them when I pivot back to you.
Okay.
Great. Mr. Bussert, good afternoon.
Good afternoon, Your Honor, and thank you. I do want to offer at least one point as to the court's belief that there was not bad faith in this. The parties litigated, just as a very brief background, the parties litigated a case for 9 months previously before Judge Ellerby that ultimately resulted in a mediated agreement. But there's a very material portion of that mediated agreement that respondent and now her counsel seem to want to gloss over. And it's specifically that in the consent order that was submitted, it says in the event that this case is dismissed, this consent order and corresponding documents referenced herein and contained in Word format between counsel via email on September 24th, 2025, shall operate as a binding agreement that shall be resubmitted for the court's approval in a new action filed in Fulton County Superior Court. The parties agree that Fulton County shall continue to have exclusive jurisdiction over this matter until the entry of a permanent parenting plan.
Was the case dismissed? I thought that the previous case was in fact resolved, and then I got to hear about everyone's moving to North Carolina, and based on that, Ms. Pinkney moved there with the kids. So I'm confused. I thought the previous case, or maybe technically it was settled because it was a mediated resolution, or was there a consent order in the end that was a byproduct of the mediation?
So,
Your Honor,
Nope. It's a question for Mr. Bussert. You'll get a chance in a minute.
So, as the only counsel present that was here as a part of Judge Ellerby in that original case, the parties at the 120-day status conference announced that they had reached a full settlement because it was our understanding we had. In preparing the parenting plan, the child support addendum, the consent final order, and all the other additions.
Petitioner's counsel introduced earlier settlement negotiations, arguing both parties had previously agreed that future custody litigation would remain in Fulton County. Those earlier understandings became central to challenging the respondents' later jurisdiction arguments.
Documents, there were a series of 4 to 5 paragraphs on 2 pages of the parenting plan that were not agreed to. The parties, through counsel, reached out to Judge Ellerby and asked for her assistance, or at least to schedule a telephone conference to adjudicate the disagreements regarding those 4 to 5 paragraphs. Judge Ellerby's response was, "You announced that there was a full settlement. If I don't have these documents by a date certain, I'm dismissing the case."
Okay.
So, respondent was bound by her previous attorney Moskowitz, to that consent order where her counsel expressly agreed in negotiations with me that those documents would be resubmitted for litigation in Fulton County. So that's the only background that I want to provide as to whether there's bad faith going.
And so I'm trying to follow here because I'm playing a lot of catch up. This action, the 26 CV action that you file on behalf of Mr. Negron, is basically what you're describing. It's getting this consent order language back in front of, it would have been Judge Ellerby, but she's moved on. Okay, so it's the reincarnation or the relitigation that was envisioned, where there was the agreement that, and when this happens, it's in Fulton County.
That is correct.
Okay. I'll continue to hear from you, but I'm going to pause you. Ms. Chauvet, you are new to the case as well, in some ways a little newer than I am, but clearly you've dived in deeper than I have. What do you have to say about there being some binding agreement that further litigation about custody and parenting plan, et cetera, was agreed to be based here in Fulton County? I'm not, if you don't know that because you haven't probed the earlier case, that's fine. I'm not trying to get you to commit. But if you say, oh yeah, no, that's exactly what everyone agreed to, then I guess I'd need to press you on a few other issues.
Your Honor, I'm not aware of that. What I did say earlier at the outset was that the agreement was never incorporated into a final order because the underlying action was dismissed without prejudice, and respondent relied upon those representations when relocating their children to North Carolina. As part of this agreement, both parties agreed to move to North Carolina.
Respondent's attorney stated she was unaware of any binding agreement requiring future litigation in Georgia. Instead, she argued both parents planned to relocate, creating a sincere belief that North Carolina had become the proper forum.
Carolina. So again, this provides important context for why respondent later believed in good faith that North Carolina had become the proper forum and pursuantly submitted that motion for reconsideration.
Got it. Thank you. Mr. Bussert, I want you to keep going, but you were providing some helpful context that I think you, other than the two actual litigants, but they're not going to be talking right now, are uniquely positioned to provide as the lawyer who's been involved with both. What is there in writing that backs up what you're saying? That basically everyone agreed if this gets dismissed, the 25 CV gets dismissed, and it's going to be brought back, we all agree that it would be brought back in Fulton rather than whatever county Raleigh is in.
Your Honor, I have the documents that were previously drafted as a part of that case. I can also provide the court with the email string between counsel related to that issue. If necessary, I can subpoena Attorney Moskowitz to appear at a future hearing. There were written emails, communications confirming this was the agreement of between counsel, which is binding on the parties pursuant to case law, that this would be the only purpose of this litigation, that respondent is now greatly expanded, and again, the continued representations that she had understandings otherwise are just not borne out by the express agreements reached by her attorney.
Well, they're not necessarily mutually exclusive. So it sounds like you've got written backup, and I wasn't pressing you because I disbelieved you. That's not the case. But other than the agency aspect, I'm not challenging you on that either, that if Attorney Moskowitz said, here's how it's going to work, he's empowered to bind his client. That doesn't mean his client knows that that has happened. And so if I'm thinking about good faith, bad faith,
Petitioner's counsel countered by referencing earlier pleadings, emails, and bold language within prior filings. He argued those documents clearly informed the respondent that Georgia retained continuing authority over the custody dispute.
If Ms. Pinckney wasn't aware of it, then I'm not so sure we jumped to the conclusion that she did it out of bad faith. Now, if confronted with it, she persists in, for example, the North Carolina litigation. I'm sort of confused how that could still be going on given the existence that you claim of these arrangements, because it seems like that would be proof sufficient to extinguish a North Carolina case, and yet it's moved far enough along that there's a hearing in front of a judge in a couple months. So that part's a little confusing to me, but other than the fact that the lawyer does legally bind the client, do you have any reason to believe that Ms. Pinckney knew that that was the situation, or understood it? Not because she doesn't get legal things, but her lawyer's talking to her a mile a minute and saying, hey, this is going to be dismissed. We've reached this settlement, blah, blah, blah. And may have mentioned something about, and if we relitigate this, it's back in Fulton. And she's thinking, now time has passed and I'm not relitigating anything. So I'm curious why you think she was fully aware of that.
Well, Your Honor, at minimum, and if you'll forgive me for 1 second, I'm pulling up the original petition that was refiled in this case. But at minimum, respondent was aware of the binding agreement prior to her filing the motion for reconsideration, because I specifically cited and in bold included it in my original response to the motion to dismiss.
Okay.
I will also note for the court that the original petition for legitimation, custody, parenting time, and child support in paragraph 2 stated respondent is a resident of the state of North Carolina and is subject to the jurisdiction and venue of this court by virtue of the Uniform Child Custody Jurisdiction Enforcement Act and the prior settlement terms negotiated between counsel. And then this was again brought up before Judge K, who is the judicial officer for Judge Ellerby at the 30-day status conference. Now, at that time, Ms. Pinckney had already filed a motion to dismiss that I had said I was planning on responding to, and filed a Rule 1004 motion, which is what has led us here. But I believe if she were questioned under oath, she would admit that she was fully aware of those terms.
I'm just looking at your response to the motion to dismiss and seeing it in big, bold. It's also italic.
The discussion broadened into artificial intelligence itself. Petitioner's attorney criticized growing dependence on AI, arguing legal professionals and litigants must personally verify every citation before presenting arguments to any court.
Emphasized. Mm-hmm. So it's extra emphasized. Okay. All right. And that was the response to the motion to dismiss. And so your point would be, all right, maybe the motion to dismiss, she didn't realize what the posture was when that previous case was dismissed, or didn't remember. But once you've put that in 14-point bold italics, and then there's a motion to reconsider, you're getting into that space of of frivolity.
That is correct.
Okay, I better understand your argument now. You can keep going.
And what I will really point out to the court, and I guess I'm one of the only remaining attorneys that wants to stand on this soapbox, but the rise and prevalence of AI is a bane to society, and the fact that it continues to permeate the judicial system represents the fact that courts and bar associations refuse to, in my opinion, properly hand out punishments for the use of AI that really should be resulting in disbarment going forward. But that being said, respondent was pro se at the time, but this representation that, she accidentally used an AI search engine while her counsel is also saying, well, she's really good at writing stuff and she's got a PhD from Emory. Those two things can't be true at the same time. Either she has the ability to research and to write, or she doesn't. This isn't someone who has an associate's degree or something like that. They can clearly see what is in the documents that they're searching. And a reasonable person would say, all right, well, let me go look for the case that I'm seeing just so I can make sure that it's correct, as someone who's had to defend apparently their dissertation. But outside of that, there is and this is arguably what makes this situation worse. The only thing that counsel and Ms. Pinckney are taking responsibility for are the ghost citation. There has been no conversation or discussion related to, as the court generously put it, the elasticity of statutes cited, which Judge Ellerby clearly agreed with when she set this down for a show cause hearing. Respondent said that the 19962A1 provides that neither the child nor the child and one parent maintain a significant connection with Georgia beyond mere physical presence. That is not the citation of that statute. Just plain and simple. And there has been no, I'm sorry, I misrepresented statutes. It's, this was an incorrect case. I realized it pretty soon after I filed the motion. Please forgive me for this case. That would make it seem like the rest of the motion was correct. It wasn't. The 1990.
Beyond the fabricated case citation, petitioner alleged statutory language had also been inaccurately represented. According to his argument, multiple legal provisions were rewritten in ways that fundamentally changed their intended meaning.
62A1 states the statute states that either of the child's parents have a significant connection with the state. So long as one parent maintains substantial connection to the state retains jurisdiction. And I cited in my response DeVito v. DeVito 280 Georgia 367 that was decided in 2006, where the court specifically held that a child that had been absent for 2 years was still bound by Georgia jurisdiction because one of the two parents didn't move out of the state. So the requirement is both parents move out of the state. That is not the case here, and that citation was a fabrication. It wasn't elasticity. The only way you could use that statute in support of her position is to change the wording of the statute, which is exactly what she did. And this entire
objection, Your Honor. That's speculation.
Well, I'm gonna let you. We glossed over the statutory citations when you and I were interacting. So when I pivot back to you, I'm gonna let you talk about that.
And again, I mean, that's not the only issue before the court. There was an additional reference to an indication that the court in future UCC JEA proceedings was required to go through some sort of analysis as to respondent specifically stated that continuing jurisdiction is not indefinite and must be reevaluated when the factual circumstances underlying the children's connections to the original forum materially changed. The statute requires the court to examine both whether children and at least one parent continue to maintain significant connections with Georgia and whether substantial evidence concerning the children's present care, protection, training, and personal relationships remains available within Georgia. None of that is correct. It is if one parent, again, the case law is clear, the statute is clear. If either parent remains in Georgia, Georgia continues to have jurisdiction no matter what the situation is. I was not able to find a single case. Now, maybe they exist. I wasn't able to find it. And the case I did find did hold that a child further away than these children was still subject to the jurisdiction of the court. But, and I guess to some extent, this really goes beyond the original issues. I mean, I'm going through, so I guess it's a twofold argument. A, there's ghost citations and complete fabrications or blatant misrepresentations of not just a case, but code sections. And the pretrial brief that respondent filed does not even even though Judge Ellerby's order addresses the fact that I pointed out more than just the case citation, respondent does not acknowledge that she completely fabricated those other positions that are still in the amended motion that she filed. So she clearly has no shame as a result to filing of those pleadings.
So I'd like us to stay out of the shame, no shame. That's not what we're here for. And I'm not attributing that to Ms. Pinckney. I think she when she was a pro se litigant, was doing her level best to represent her position. It sounds like partnering with AI, she inadvertently.
The judge carefully separated emotional accusations from legal analysis, explaining the hearing was not about assigning shame. Instead, the court needed to determine appropriate consequences for submitting inaccurate legal authorities during active litigation.
Or purposefully took some liberties with what statutes say and what cases are there. I'd like to know what you think the consequences ought to be, Mr. Bussert, and then I'm going to turn back to Ms. Chauvet to let her talk about the statutory citations or miscitations. And she said she had 4 points in closing she wanted to cover.
So, Your Honor, as the court, I know the court is just coming on to the family law bench, but a unique aspect to family law that is different than other civil litigation is that the striking of pleadings ultimately doesn't serve any purpose in family law because the court is always required to go through whatever analysis is related to the original pleading or to the counterclaim. So the only thing available to the court, if the court's going to order a remedy, is an award of attorney's fees. The singular exhibit that we submitted was a request for attorney's fees in the amount that had been incurred prior to date of $2,042. To the extent that Respondents Counsel wants to cross-examine me, I can put that up as the exhibit 1 of $2,042. And with the additional hour that we are in court today, that would bring the total to $2,417 that we are asking the court to award in terms of attorney's fees pursuant to 915.14b. Obviously, due to the failure to comply with the court's requirements regarding AI usage, but B, because at least as it relates to the motion for reconsideration, it was entirely frivolous because any argument that she may have had prior to the original motion to dismiss was gone as a result of my response that clearly identified the parties' agreement. Outside of that, I've been an attorney practicing exclusively family law for going on 11 years now. I bill at a rate of $3.75 an hour. I've been recognized as a rising star in super lawyers for the last...
Objection, Your Honor. Relevance.
So, Ms. Chauvet, he needs to do this unless you are choosing not to challenge the reasonableness of his attorney's fees. And if you, I'll let you know, based on his experience, that hourly rate seems reasonable, but unless you stipulate that it's a reasonable rate, he's got to tell me a little bit about his qualifications and any honorifics he's got, because that goes into the weighing I do to say $3.75, that's crazy. You're a first-year associate and you've never handled a case, versus you've been practicing law for over a decade in this field. You've been recognized as whatever he was about to say. So if you're not going to be challenging his qualifications, I'm happy to cut him short.
Your Honor, we do not.
Attention then turned towards sanctions. Petitioner requested reimbursement for attorney's fees, arguing the motion for reconsideration became frivolous once earlier filings clearly identified Georgia's continuing jurisdiction and prior settlement obligations.
Challenge his qualifications. This is something that I actually investigated in the past day since I've joined this case. It seems reasonable, although all of his other arguments are pure conjecture, and I'm looking forward to responding to each of them.
All right, well, you'll get that time in just a moment. So, Mr. Bussert, it looks like your exhibit is good to go, and then we would add an hour to that 2042 figure.
Yes, Your Honor.
Okay. All right. Anything else on behalf of Mr. Negron?
No, Your Honor.
All right. Ms. Chauvet, you have listened patiently, so you can do at least two things. One, any response you've got to what I just heard from Mr. Bussert. And then two, you had said you had 4 points you wanted to close with, and I promised you we'd come back to those. And so I'm here to do that. And then anything else you can fit into the remaining 10-ish minutes.
Yes, Your Honor. Thank you for the opportunity to respond. I understand that we are at the close of the business day, so I will aim to be succinct. Now, regarding the citation error, again, it was inadvertent. It was not intentional.
When you say citation error, you mean to the case, or are we now talking about the statute?
We're talking about the case.
Okay.
Again, the motion for reconsideration was filed to present additional sworn evidence relevant to jurisdiction. It was not a frivolous matter. It was based on a genuine dispute regarding the proper form pursuant to the UCC JAA. The motion itself reflected a genuine legal disagreement regarding jurisdiction, not delay, not harassment, not abusive process. Again, I want to reiterate that respondent actually filed her North Carolina custody action on February 11th. This was about a month before she ever received notice about this Georgia action. She has a hearing that's pending September 9th, and any matters related to the statute itself, and I'm hearing a bit of an echo, is pure misinterpretation of the statute, which can occur with pro se litigants. It was not intentional by any means. In fact, there is a more appropriate statute here concerning why North Carolina is a more appropriate forum under OCGA 19-9-67, but I will leave it at that, given the amount of time remaining.
Okay.
So, in closing, I want to, again, ask the court respectfully to find that the citation error was inadvertent rather than intentional, deny petitioner's request for sanctions and attorney's fees, as the motion for reconsideration was intended in part to bring evidence to light of the parties' intentions and expectations via the mediated settlement agreement, in which both parties noted and agreed to move to North Carolina by December 27th of 2025. This was not a frivolous filing, and I think it's also important to consider the equitable financial circumstances presented and the impact that it would have.
Respondent's attorney maintained the mistaken citation was accidental and immediately corrected. She insisted the filing reflected an honest jurisdictional disagreement rather than harassment, delay, or any intentional attempt to mislead the court.
Have to 3 young children, a 3-year-old and twin 5-year-olds, that have been solely supported by respondent.
Objection, Your Honor.
If
91514B, which is the relief requested, doesn't take into consideration financial circumstances.
Okay, I will, if I'm going to be relying on a statute that requires me to take into consideration financial circumstances, I will certainly ask both sides to provide additional information on that.
Yes, Your Honor. Moving onwards. If appropriate, we also respectfully request that North Carolina, per Code 19-9-66.
Objection, Your Honor. This is a show cause hearing. This is not anything to do with North Carolina.
Okay, well,
Your Honor,
I don't even know what her point was yet, so just hold off, Mr. Bussert. Let me hear what she's going to say, and then I can process whether I need to rely on that. So if you'd start that sentence over again, you were given a citation. I couldn't tell if that was going to be a North Carolina citation or Georgia, so take me through it again, please.
Your Honor, before I was interrupted, I was going to say that this is in relation to the point that there are two actions that are simultaneously occurring. So to your point about the next steps, if appropriate, we respectfully ask that the court confer with North Carolina per Georgia Code 19-9-66 before making any sort of jurisdictional determination moving forward, and then grant any other relief as the court deems appropriate. Thank you.
Okay. Thank you for that. Mr. Bussert, give me your thoughts. I'm curious, what is your connection, if any, to the North Carolina litigation? You're aware of it, you actually are barred, and so you are representing Mr. Negron there, or what's happening with that case from your client's perspective, as best you know?
The extent that I have any information is when he was served with that action, he retained local counsel in North Carolina, and I had maybe a 15-minute conversation with them probably about 3 months ago, and or 2 months ago. It was some time ago, and have not had any further conversation. Mainly to the point of there is no conversation to be had, because Judge Ellerby has ruled now twice on this issue, and it appears that respondent's attorney is now asking the court to engage in this analysis a third time. But to be clear, all of this would ignore the binding agreement between the parties.
Okay, I got that, and I'll sort out the Georgia end of things, but it sounds like you don't know if there is in the docket in North Carolina a motion to dismiss from your client because of what you say is the binding agreement that jurisdiction, everyone's agreed that jurisdiction.
Respondent further requested coordination between Georgia and North Carolina courts, emphasizing that parallel custody proceedings remained active. The judge acknowledged the concern while keeping the hearing focused on potential sanctions.
For this dispute is here in Fulton.
I do not. I will, to the extent that it keeps being brought up, I will note that the filing in North Carolina did not meet the 6-month requirement, because there is this continued reference to February 11th. The parties there was a guardian ad litem. And
what's a 6-month requirement?
So to the extent we're going to invoke the UCCJEA, and that the new home state of a child would be determined, let me back up. When there is an initial determination of jurisdiction, this does not apply for exclusive continuing jurisdiction, but for the determination of initial jurisdiction, the court has jurisdiction where the minor children have resided for the last 6 months. And that is the argument that respondent appears to be relying on, although Judge Ellerby twice has said Fulton County has exclusive jurisdiction regardless of whether the settlement agreement is binding or not, which it is. So, I mean, Judge Ellerby determined that court had exclusive jurisdiction regardless of the settlement agreement. We're contending the court has jurisdiction both under continuing and under the binding agreement. But to point out again, as the history of this case, there is a standing order that goes into place when these cases are filed in family court. that order is the children are not to be removed from the jurisdiction of the court absent agreement or order of the court. There is a guardian ad litem, Patricia Shoemaker, who specifically said that she did not consent to those children being removed from the jurisdiction except for the purposes of a visitation or vacation period. The parties did not reach a mediated agreement that would represent the finality of these issues until August 20th. So the first date, if we're going to say Fulton County did not have exclusive continuing jurisdiction, if we're going to say that there was no binding agreement that she was bound to by her counsel, she still had to wait until February 20th, which was the day the parties reached the mediated agreement authorizing the children to move. So she would have to refile that case in order to invoke UCCJA. And that has also been brought up.
But I appreciate the argument.
Petitioner responded by arguing North Carolina lacked proper jurisdiction from the beginning, maintaining previous agreements, and Georgia law supported keeping the custody dispute exclusively within Fulton County, despite the ongoing proceedings elsewhere.
We just don't know the status. We do know the status. There's a hearing in a couple months, and according to Ms. Chauvet's understanding of the docket there, it's alive and well. Mr. Negron has counsel. It's not you. I, of course, am not imbued with the authority to tell North Carolina what to do with its case. It might not be a bad idea to check in with that judge, but that doesn't mean that I am ceding jurisdiction to that judge or anything like that. But it's certainly not efficient for your client or for Ms. Pinckney to be fighting the same battle in two fora. That's not how it ought to work. So I'm a little surprised if everything is as you're describing, Mr. Bussert, why the North Carolina case persists. But North Carolina law is not Georgia law. Maybe there's a reason, and we'll see. But I really don't mean for you or Ms. Chauvet or Mr. Negron or Ms. Pinckney to have to wrestle with the ultimate issue of custody and parenting and whatnot in two different places. That's in no one's interest.
Your Honor, if I may add just a couple points.
Okay.
So Judge Ellerby actually denied the previous motion due to issues with the exhibits. This was back in, I want to say, either March or April, which is part of the main reason why my client decided to file the motion for reconsideration, for all the reasons that I indicated earlier with respect to my argument for good faith. Also, in terms of good faith, we respectfully rebuke the personal attacks against Ms. Pinckney. Yes, she is educated, and educated folks use Google quite often to research statutes, for example. The UCCJA is publicly available. So are a series of cases. She was not aware that Google added a new AI feature entitled Google Overview. So again, this was a genuine mistake. It's something that she has been extremely apologetic about, and we respectfully ask the court to be cognizant of that in making its final determination.
Okay, well, I appreciate that. We're going to bring this to a close. I will note this so no one is surprised by any ruling that's going to flow from this. There's nothing magic or mystical about this AI concept. The issue here is the presentation to a judge of material that isn't what you say it is. And whether it came from AI or, I mean, heck, back in the olden days, probably well before some of you all, if you didn't shepherdize, you pick out the wrong book and it's from 1872 and that's what the case law was, and you don't know that in 1904.
Before concluding, respondent's attorney defended her client once more, explaining that Google's AI overview had been mistakenly trusted. She stressed the citation error was promptly corrected and reflected negligence, not intentional deception.
They changed it. You cite that 1872 case. There's no AI. There's no computers. There's electricity and the lights, and that's it. But that's sanctionable, as in you could be in trouble for it because you didn't do your homework on this. And so I'm not wrapped around the AI mantle. And did Ms. Pinkney know that there was an AI agent assisting Google? She got information from a source, the credibility of which she knew could be called into question, because you can go into Google and say, what should I do about COVID? And you could find, take pesticide. That doesn't mean you should take pesticide, but that's out there. And then you need to verify. And clearly that verification didn't occur. So I don't attribute to Ms. Pinkney some lack of education or anything like that, because she relied on information from the internet. In fact, that's a smart thing to do, as long as you are cautious about how you use what you get. And I think Mr. Bussert is not out of line in pointing out that there was a lack of caution here. Once it was recognized, some of it was corrected. I think the harder part to correct was maybe the over-reliance on some authorship around what statutes say and don't. But the die's been cast, that's been filed, and I need to figure out what the consequences are for filing something like that in the face of Judge Ellerby's very clear directions about relying on information that you don't take the time to verify. So I will get an order out soon on this. Next steps for this case would be, there was
The parties had
Better be a
recently-
conference with North
you have a
Carolina
120-day status conference on
in
the
August.
with me. All right. So we will be together then. My recollection, as I'm climbing this steep learning curve here, is that you all must meet. Oh, you've got your order for mediation. So you all will mediate before that status conference. Just so everyone's clear, I don't want there to be any surprises. That is sanctionable to show up at the 120 and not have mediated. So if one side's planning on being difficult, I'm not talking about the lawyers, I'm talking about the clients. Just know that a refusal to sit down at the table doesn't end well at that 120 conference. One of the first things I ask is, how did mediation go? And if mediation didn't go well, that's okay. That happens sometimes. But an answer of, we didn't mediate because person X wouldn't show up, that's a bad outcome for the person who didn't show up. So take care of that. I will see you all on the 20th of August. I'll obviously have an order in place on this well before then.
Delivering final observations, the judge explained that artificial intelligence itself was not the true issue. The real concern was presenting unverified legal authority to the court without carefully confirming its accuracy beforehand.
And Ms. Chauvet, you are counsel of record for Ms. Pinkney until you withdraw. I appreciate that you are right now out of your own largesse assisting Ms. Pinkney with things, but until you file to withdraw, I'll be turning to you for responses, for an appearance at the 120 day, etc. So I look forward to that. Is there anything else? I'll just start on petitioner side, Mr. Bussert, that we need to cover to clear up any confusion or to make certain what deadlines are and expectations are for the Georgia case?
No, Your Honor.
Okay. Ms. Chauvet, anything from your side?
Yes, Your Honor. Concerning the status conference on August 20th, will this be in person or online?
It is virtual.
Virtual. Great.
Yeah, you're welcome to be in person, but the default is virtual.
Okay. And then concerning the conference with North Carolina, again, there are 2 actions pending. Is this something that the court will take into consideration in terms of resolving jurisdiction?
Yes and maybe is what I would answer. I would like you, please, to share with Ms. Niles, my staff attorney, obviously copying Mr. Bussert on anything you send, the case information about North Carolina, by which I mean only style of the case number, and most importantly, judge and any contact information you have for that judge, whether it's an email for the judicial assistant or staff attorney. But even if you hadn't asked for it, my plan is to reach out to that judge to say, all right, what's going on? I don't want our trains to collide on the tracks. And so we will do really what we ought to do when the same matter is pending in two jurisdictions. I would do this if this were a car crash case or a criminal case. I don't know how that could happen, or a family case. We won't talk about jurisdiction, but we will talk about who's doing what next and all that. So that would be very helpful. I think that's it. Thank you, everyone, for dialing in. Mr. Negron and Ms. Pinkney, we didn't get to talk, but that's not the purpose of today's hearing. I appreciate your attendance as well. And you all will also be online for the 120-day status conference. It's infrequent that I meet with the lawyers without the clients, so that we protect the lawyers from a scenario where they go back and tell you and you say, I don't believe that's really what happened. You're gonna hear it from me, and you can fuss at the lawyers about what a wingnut I am, but at least you heard it from me and not filtered in some way through the lawyers. So I will see all four of you at the 120-day conference, and we will go from there. Mr. Bussert, last chance. Anything else?
Nothing else, Your Honor.
Thank you for your time. Ms. Chauvet, anything else?
Yes, Your Honor. Should I contact Ms. Nils about the information for the August 20th status conference?
We will push something out to you all about the Zoom link and what you need to be prepared to discuss at the conference. So you'll get something from us.
Okay, thank you very much.
All right. Thanks, everyone.
The court reserved its decision on sanctions, confirmed future mediation requirements, and announced an upcoming virtual status conference. Both parties were reminded that failing to participate in mediation could carry serious consequences. The hearing concluded. The judge requested information regarding the North Carolina case to prevent conflicting proceedings. With no immediate ruling issued, both sides departed awaiting the court's written decision on sanctions and future jurisdictional steps.